what he's probably referring me back to those to show what uh, the history and the intent was. That's a yes. I'll have to wait and see. All right, are you in? You're not in yet, but are you on? Ready?
I'm waiting to, I'm
Okay.
fixing to click in.
I'm joining. I'm getting YouTube going. That's a yes. I'll have to wait and see. All right, are you in? No, you're not in yet, but are you on? Ready? Okay. I'm joining. I'm getting YouTube going. Let's see. Can I do?
And you go about 11:15.
Mhm. Kayla, do you have YouTube going? You see it? Okay. Terry shows it. So.
Okay.
Oops.
right, I'm ready to start admitting. Are you into the Zoom hearing? Are you ready? Well, we won't immediately be on the record. Okay, here he goes. Okay.
Who's Amanda Crouch?
All right, good morning, everyone. It's 9 o'clock, and I have admitted to the Zoom conference everybody that has sought to be admitted. If anyone cannot see who is present with us, let me know. But I'll take announcements, and everybody will identify themselves in just a moment. So let's get started. This is a hearing in cause number 26,824. The case is styled Creekside Rural Investments, Inc., Manor Ranches, Ltd., and J. Dickens as plaintiffs versus Dan Hicks and Pam Browning as defendants. This is a hearing on various motions that have been filed by the parties. We will get into that in just a moment, and we'll take announcements in just a moment. First, though, because we are conducting this hearing by remote video teleconferencing technology using the Zoom protocol, there are certain announcements that are pronouncements I am suggested by OCA guidance to give. The first one would be that this proceeding is being live streamed on the court's YouTube channel so that the public would have the right to attend court. The public has the right to attend court, but as I say, following OCA guidance, we are live streaming this matter. The public is also has access to this proceeding because the Scurry County Courthouse is not closed. It is open to the public. There are COVID safety measures in place for the public who seeks to attend, such as temperature screening, admonishments about social distancing, the COVID questionnaire that essentially exists for jury persons is also used for members of the public who desire to attend. The courtroom of the 132nd District Court, where I am seated right now, is also open to the public. At this point in time, however, there is no one present in the courtroom of the 132nd District Court, other than myself and the court reporter who is transcribing these proceedings, which leads to one last pronouncement. Just as we do in any live proceeding, there is only one person authorized to record this proceeding or transcribe the proceedings, and that is the official court reporter who is attending these proceedings by Zoom, as well as each of you are. But he is also physically present and social distanced from me in the courtroom. Since he is the only one who is permitted to record and or transcribe these proceedings, let me just make it a little clearer. Everyone or anyone is expressly prohibited from recording this proceeding or any portion of it by any means, electronic or otherwise. To violate that order subjects the person to contempt of court. With those pronouncements made, I am going to call for announcements. I first recognize Mr. Odell, since you filed the first motion that will be taken up this morning. Mr. Odell, are you ready to proceed?
Your Honor, Brad Odell here on behalf of Ms. Pam Browning, the guardian of the person in the state of Mr. Stacy James Browning, and we are present and ready, Your Honor.
Tell me that you have filed that have been scheduled actually by agreement of all the parties. What are those matters?
Your Honor, we have filed our plea to the jurisdiction of this court regarding the standing of the plaintiffs to bring this lawsuit against Ms. Browning. We have also filed a companion motion to dismiss pursuant to Rule 91A. And then we've filed a motion for sanctions.
All right.
Those are the motions that we have filed, Your Honor.
All right. Next, I would recognize Mr. Wymore. Mr. Wymore has also filed a motion that by agreement of the parties was scheduled for hearing today. Mr. Wymore, and I note Mr. O'Toole is present as well. Are you ready to proceed? Mr. Wymore, you're still muted.
Apologies. Judge, Mr. O'Toole and I are ready to proceed. A couple of caveats. The first would be that I think that you certainly properly identified that plea to the jurisdiction filed by Mr. Hicks and Mrs. Browning must go first, but then ultimately I believe that procedurally our anti-SLAPP motion must be heard before Ms. Browning's motion for sanctions can be heard. Last point I'll make, Judge, and I'll be brief. I know that we have previously emailed to your coordinator a letter outlining that our first amended petition was filed and has been properly accepted, naming you as a defendant in this matter. There's a fundamental principle under U.S. law. It's been reiterated by the Supreme Court, and that is no man is allowed to be a judge in his own cause. And there's certainly various reasons cited for that, but it's reiterated in Texas case 263 Southwest 3rd 93, and also by the United States of the Supreme Court at various points. For those reasons, we would ask that Your Honor respectfully decline from proceeding with hearing this matter, so that we can get citation issued and move forward. With that, I'll go back.
All right. Also note, if you would, that Mr. Dickens is present and with us in this Zoom hearing.
Yes.
All right. Because of the matters that you assert are not before us this morning, and because this individual as judge of this court is not in this lawsuit, we will proceed. I next recognize Ms. Crouch. Am I pronouncing that right, Crouch?
Yes, Judge.
All right, and you are, give me your announcement. Are you here on behalf of defendant Dan Hicks?
Yes, Judge. Good morning. Amanda Crouch on behalf of defendant Judge Dan Hicks. And we have filed a plea to the jurisdiction that is set to be heard this morning by agreement of the parties, and we are present and ready.
All right. Mr. Odell, I believe the suggestion from Mr. Wymore that you should be the one going first is an accurate and good suggestion. And so I turn to you, and we'll take up defendant Browning's plea to the jurisdiction and motion to dismiss, as well as defendant's Rule 91A motion to dismiss. Let me do a administrative action and see if this will work. Now then, and Mr. Odell, you may proceed.
Thank you, Your Honor. Again, Brad Odell here on behalf of Mrs. Pam Browning, the guardian of the estate and person of Mr. Stacy James Browning. Your Honor, our plaintiffs have filed a lawsuit against both Mr. Hicks and Ms. Browning, asserting damages arising from the operation of a shooting sports range in Williamson County, Texas. The plaintiffs petition, both the original petition that was filed and also plaintiff's second amended petition, and even its first amended petition that have been filed in this cause, allege that the plaintiffs have been damaged by my client on account of the actions and the operation of a gun range down in Williamson County. The gun range is situated on property which is owned by the ward in the guardianship proceeding, Mr. Stacy James Browning, in which his mother acts as the guardian. Without belaboring what I believe this court has already known based on the prior hearing that was held in cause number 26683, in which these same plaintiffs were attempting to intervene into the guardianship estate of Mr. Browning, I'll go straight to what are the cause of action that has been alleged by the plaintiffs against Ms. Browning in order to best address the issue on the plea to the jurisdiction, as well as our motion to dismiss pursuant to Rule 91A. In particular, and with all candor to the court, I was a little confused as to exactly what these plaintiffs have been suing my client for. The part of the petition in particular, where it goes to states a violation of Texas Estates Code 1151.105. This is on, Your Honor, if you've got pulled up, I'm looking at the second amended petition, and that's what I'll be referencing during this hearing. It starts on page 18. Your Honor, you'll note that it starts with basically a section of liability in general, cites to section 1151.105, then cites to a provision that actually that relates to immunity for attorney ad litem's, and asserts that guardians are not entitled to immunity for such actions, and goes on to essentially, based on further pleadings that have been filed by the plaintiffs in this matter in responses to our motions, our plea to the jurisdiction. Well, Your Honor, I should also point out for the court, based on the pleadings that were filed yesterday, the plaintiffs did not actually file a response to our plea to the jurisdiction. They filed 2 times responses to our motions for sanction, and then a response to, they did file within 7 days of this hearing, a response to our motion to dismiss pursuant to Rule 91A, and they also filed a reply to our response. But on file with the court, based on the pleadings that came across my desk yesterday, there was never filed a response to this plea of the jurisdiction. And I just point that out to the court. Next in the petition, Your Honor, it then jumps into and asserts that Ms. Browning has violated Code of Ethics of Minimum Standards for Guardianship Services. These are promulgated by the Texas Supreme Court and apply to professional guardians and guardianship programs. They do not apply to guardians who are appointed and are family members of the ward. And therefore, I wasn't quite sure exactly what that meant, which then left, Your Honor, the fiduciary duty part of their petition, which starts on page 19, in which they assert that Ms. Browning has violated fiduciary duties, and then goes on in a section D and reiterates much of the same thing that they just stated about violating the Code of Minimum Ethics, or the Code of Ethics and Minimum Standards for Guardianship Services, as well as breach of fiduciary duties, and essentially finishes off with this paragraph at the end. The code requires the guardian avoid even the appearance of a conflict of interest or impropriety when dealing with the needs of the ward. Impropriety or conflict of interest arises where the guardian has some personal or agency interest that can be perceived as self-serving or adverse to the position or best interest of the ward. A conflict of interest may also arise where the guardian has dual or multiple relationships with a ward which conflict with each other, or has a conflict between the interests of two or more wards. Guardian has blatantly violated the code. I bring this all to the court's attention, basically again to state with candor, Your Honor, based on this pleading, it was my understanding they were attempting to say that my client has breached fiduciary duties, and because of these breaches, they are entitled to damages. I have since learned that they are asserting that under section 1151-105, their client is entitled to damages, in particular under paragraph B of that provision. Because these plaintiffs cannot show, as it pertains to that statute and this lawsuit, cannot show that they have standing, this court should dismiss this lawsuit. Standing requires that the defendant or the plaintiffs show that they have an injury in fact, that the injury in fact is actually traceable to the defendant's wrongful conduct, and not the independent action of a third party. And they also must be able to show, Your Honor, that the alleged injury will be redressed by this court. They fail to show in their pleadings, and they'll fail to be able to show that pursuant to 1151-105, that they'll be able to show standing. And first and foremost, one is section 1151-105 deals with the guardian's duty to exercise ordinary diligence in either collecting funds, debts, claims owed to the ward, or recovering property that it belongs to the ward. B, that's subsection A, Your Honor. Subsection B, or paragraph B of that same section, section 1151-105, deals with and addresses what would be the measure of damages or liability in the event that the guardian fails to exercise such care or such ordinary diligence. It does not provide a separate standalone grounds for liability. It does not create some sort of broad relief allowed that the guardian must act in ordinary diligence in all things that he or she does. Instead, it provides that, as it states, if the guardian willfully neglects to use ordinary diligence, the guardian and the sureties on the guardian bond are liable on the suit of any person interested in the estate for the use of the estate, the amount of the claims, or the value of the property that has been lost due to the guardian's neglect. Those that language there, Your Honor, deals with subsection A. Did the guardian properly use their ordinary diligence, in this case, Ms. Browning, in collecting claims owed to the estate or property that she needs to recover for the estate? Plaintiff's claims don't fall into those categories. They cannot show an injury, in fact, that Ms. Browning's actions has somehow caused a loss of a claim or debt she should have collected or recovery of property owed to the estate. They can't show that they've been injured by those actions. They can't even show, Your Honor, and have not even pled that she's actually violated that statute or not used ordinary diligence. They provide no evidence, no pleading that would show, no allegations that would even allege that she's failed to use ordinary diligence in accomplishing subsection A of section 1151.105 of the Texas Estates Code. So first off, they can't satisfy the injury in fact. Second, Your Honor, they can't show that anything, even if they could show an injury, or even if their injury that Mr. Dickens and his, or the plaintiffs are alleging, which are the damages that they're asserting in the Williamson County lawsuit of lost profits, damages to his property, and the other sorts of damages that they've alleged here, even if they could show that that is their injury that would allow for them to be able to sue Ms. Browning under 1151.105, they cannot show that her actions have caused or are fairly traceable to those injuries. In fact, they allege that she leased a piece of property to an entity which is owned by her son-in-law, and that she leased it for an amount less than what it should have been. Well, the amount there would be, if there is a discrepancy or if there is a damage there, it would be for the fair market value of what that lease should have been, and not for the damages that these plaintiffs are seeking. Instead, what they're seeking are damages caused by, as they put it, and as they state throughout this petition, and as they stated throughout the hearing we had in the matter of 26683, that they've been damaged because bullets are escaping the range is unsafe, and therefore they have been damaged because they can't sell the property they're trying to develop in Williamson County to sell off to third parties. Those damages are not caused by my client. My client has not caused those damages by leasing that property. Further, and as previously stated, those damages don't even arise in this situation if Ms. Browning had actually violated 1151.105, because the damages are limited to the amount of property she didn't recover, or the value of the property she didn't recover for the estate, and the amount of the claims or debts that she failed to recover for the estate. They're not just some blanket amount of damages that the plaintiffs and Mr. Dickens want to allege in this lawsuit. For those reasons, they fail to satisfy the second prong of standing, which is that the alleged injury is fairly traceable to the actions of the defendant. Finally, Your Honor, they've got to show that what you would grant under 1151.105 would actually be, or would actually redress their injuries. And they can't do that either. So even assuming, for argument's sake, that they're able to show an injury in fact, and that is fairly traceable to the actions of my client, the remedy as prescribed by section 1151.105 is this. If the guardian willfully neglects to use ordinary diligence, the guardian and the sureties on the guardian's bond are liable on the suit of any person interested in the estate. And I highlight this language, Your Honor, for the use of the estate the amount of the claims, or the value of the property that has been lost due to the guardian's neglect. In other words, any relief that you were even able to grant under section 1151-105 would not go to the plaintiffs. Instead, it would go to the estate. That's what section 1151-105 provides. It provides that the damages in the event that the guardian fails to exercise ordinary diligence and willfully neglects to do so, then the guardian is liable and the bond is liable in the amounts of the claims not collected or the value of the property, but those damages run to the estate and not to whatever interested party brought it in. And Your Honor, that makes sense, because really you're not entitled to more than what you're entitled to against the guardianship estate. As a hypothetical, Your Honor, if a guardianship estate owed me $1,000 and I knew that the guardianship estate had a claim against ABC company for $10,000 and failed to go collect that claim, and because they failed to go collect that claim, they couldn't pay my claim, I can't sue the guardian, assert the liability under section 1151-105, and then collect $10,000. I'm only entitled to collect what is the value of my claim. So that $10,000 that I would go and have this court order or hold the guardian liable for failing to use her ordinary diligence under section 1151-105, those damages would come in and be part of the estate. So again, the third element of standing, Your Honor, that the plaintiffs cannot meet in this lawsuit is that they must show that the injury is not, that the injury can be redressed by this court. Their own pleadings are saying they're suing under 1151-105. 1151-105 does not allow for them to reach the conclusion that they wanted to reach. Now, Your Honor, and this will apply to both my motions, but Your Honor, they assert that there's a companion or a sister provision in the in the estates code at section 2. No, forgive me, Your Honor. Let me make sure I pull it up and cite it correctly. 351-151. This provision deals with similar requirements for a personal representative of a probate estate. And Your Honor, they point out that there's some different language, and admittedly there is in the subsection B, and that is in 351-151, the language points to it references subsection A, whereas in the 105, Your Honor, it does not reference subsection A. And for those reasons, they assert that somehow this subsection B morphs into this general ordinary diligence requirement that anybody can come in and sue a guardian because they didn't use ordinary diligence or willfully neglected to use ordinary diligence in whatever it was that they're doing. Your Honor, they state that had the legislature wanted to use the language similar, they would have, because both of these sections were passed at the same time. Your Honor, the truth of the matter is this court's well aware, in 2014, the probate code and estates code were recodified into the estates code. The truth of the matter is, Your Honor, and I sent this to Ms. Phipps prior to the hearing. I don't know if you have it before you. I hope that you do. But section 1151 of the estates code, section 1151-105 of the estates code actually comes from the prior probate code, section 772. And I apologize, Your Honor, I rely on books more so than electronic researched many times, and so I have a copy from a probate code book that provides you with exactly what 772 said prior to its recodification in the estates code. And you'll note that it says the exact same thing as section 1151-105, save and except it's just one provision. There's no subsections, paragraphs, however you want to phrase those. It provides every guardian of an estate shall use ordinary diligence to collect all claims and debts due to the ward and to recover possession of all property of the ward to which the ward has a claim or title if there's a reasonable prospect of collecting the claims or of recovering the property. And then it goes on to say exactly what it says in B. If the guardian willfully neglects to use ordinary diligence, the guardian and the sureties on the guardian's bond shall be liable at the suit of any interested person in the estate for the use of the estate, for the amount of the claims, or for the value of the property that has been lost due to the guardian's neglect. Your Honor, the legislature didn't change in the recodification of section 1151-105 the meaning behind this statute. This statute has always meant the duty of the guardian is to go out and collect the debts and claims owed the guardian and recover property for the guardian. And that guardian has to use ordinary diligence to do so. If the guardian fails to use ordinary diligence to do so, then the guardian, and willfully does so, then the guardian is liable as well as the guardian's bond. And the amount of the claims failed to recover or the value of the property lost, and all those benefits go to the estate. They do not go to plaintiffs or any other interested person. In fact, that's not what the express language of the statute says. So again, to our motion to dismiss based on jurisdiction, Your Honor, they don't have standing. They can't show that they have an injury in fact based on the statutes and the claim that they're bringing. They can't show that that injury is traceable to my client's actions, especially under section 1151-105 of the Estates Code. And they can't show that this court, if this is the law, if this is the provision they're suing under 1151-105, they can't show that this court will provide the redress that they're seeking, which is for damages of lost profits, opportunity costs, so on and so forth, to run to these parties. And for those reasons, plaintiffs lack standing, this court lacks subject matter jurisdiction, and this lawsuit should be dismissed as to Mrs. Pam Browning, guardian of the estate and of the person. Now, Your Honor, that's basically the argument for our motion or our plea to the jurisdiction. As you can imagine, our motion to dismiss basically follows the same line. Rule 91A provides that if the plaintiffs fail to state a cause of action or a claim upon which relief can be granted, the court can dismiss the lawsuit. And Judge, that's exactly what we have here. Again, with all candor to the court, again, as I read the petition, as I read and tried to understand what exactly they were arguing, my best guess, and maybe shame on me, was that they were trying to assert that Ms. Browning owes these plaintiffs fiduciary duties, which of course they've now admitted in pleadings that is not what they're suing for. So again, going back to 1151-105, that provision deals with a guardian's duty to collect claims owed to the estate, property owed to the estate. And if the guardian willfully neglects to do so, then somebody can come in that's interested in the estate, can come in and sue the guardian and the bond or its sureties and recover for the estate. Now, because of that, Your Honor, they don't state a claim under this provision because none of their allegations go to my client's neglect or willful neglect to use ordinary diligence to go out and collect claims or debts owed to the ward, nor do they allege any facts or plead any facts that assert that my client has willfully neglected to use ordinary diligence to go out and recover property of the estate. Further, they can't show that there's been any damages for any of those things. Their damages that they assert have nothing to do with whether or not there's been a loss of property for the estate or a failure to go out and collect debts. And because they can't meet these prongs of section 1151-105, they failed to assert a claim upon which relief can be granted. Similarly, even if there is some allegation that meets the ordinary diligence requirement or meets the requirements of subsection A, in which my client has violated, they're not entitled to the relief that they're requesting. Again, the relief provided for under subsection B of 1151-105 is that the value of the claims failed to be collected and the value of the property failed to be recovered comes into the estate, not to the plaintiffs. And because they have failed to meet the pleading requirement of stating a claim upon which relief can be granted, Your Honor, this court should dismiss this lawsuit against Ms. Browning. And for these reasons, that's exactly the relief that we're requesting. We're requesting that this court dismiss this lawsuit and allow Ms. Browning to go on her way. Now, we have separately filed a motion for sanctions, Your Honor, as you're well aware. However, I will point out that Rule 91A provides that a prevailing party on a motion to dismiss is entitled or may receive and recover their reasonable and necessary attorney's fees and costs incurred in the case. And therefore, if the court grants our motion to dismiss under Rule 91A, we would ask that we be authorized to submit an affidavit to address that award and award Ms. Browning her reasonable and necessary attorney's fees and costs incurred as it pertains to the motion to dismiss. Your Honor, I would have submitted an affidavit earlier. However, due to the various motions that have been filed, I felt it was best to address an affidavit that addressed the court's ruling. And so if it's okay with the court, I'll submit such an affidavit upon the ruling of the court.
Anything further?
That's all I have, Your Honor, on these two motions.
Mr. Wymore, I'll give you an opportunity to respond, or I will give you an opportunity to respond after Ms. Crouch presents her plea of the jurisdiction. As I understood your suggestion as we began, your particular motion to dismiss would come into discussion and play after both defendants' pleas to the jurisdiction were heard. But I will give you the opportunity to respond first to Mr. Odell, or, as I say, to wait and then respond to both at the same time. What is your pleasure? You're muted again.
Pardon me. Thank you, Judge. I'm going to make two quick points, and then Mr. O'Toole will handle the response to Mr. Odell's arguments. First point is, Mr. Odell stated that we did not file a response to the plea to the jurisdiction. That is false. I emailed, re-emailed when Mr. Odell was arguing to all parties a copy of our response to the plea to the jurisdiction. That was filed at 5:15 yesterday afternoon, and shortly thereafter was emailed to your coordinator and all of the council. Secondly, Mr. Odell has taken the position that it was not clear what our causes of action were, Judge. However, on July 27th, if you'll take a look at paragraphs 8 through 10 of our anti-SLAPP motion, what you will see is that we clearly and unequivocally state in that anti-SLAPP motion that we do not bring independent and separate causes of action for violation of the Code of Ethics or breach of fiduciary duty, only a cause of action under 1151-105. So to the extent that there was any doubt as to what causes of action were being asserted, that should have been cleared up at the end of July. Third point is a Rule 91A motion I would submit can only be ruled upon if this court in fact decides that it does have jurisdiction. If this court decides that it does not have jurisdiction, then we would submit that there is no authority upon which to rule on any other motion, including Ms. Browning's 91A motion, Ms. Browning's motion for sanctions, and plaintiff's anti-SLAPP motion. With that, I'll leave it to Mr. O'Toole.
Mr. O'Toole.
Good morning, Your Honor. Your Honor, Mr. Odell went through a very lengthy response there where he issued a number of very authoritative pronouncements, really as if Ms. Browning and her counsel have the ability to declare what the law is. Our position is different, Your Honor. We are going by what the language of the statute says. The language of the statute simply does not provide, as Mr. Odell would have you believe that it does. His conclusions are not supported by traditional principles of statutory construction. It's the first thing we all learned in law school, or one of the first things. You assume that the legislator included or omitted words or phrases for a reason. You don't ever assume that the legislature did a useless act. Where that is very significant here is we have basically two versions of the same statute in the Estates Code. One applicable to personal representatives of estates, that's section 351. One applicable to guardians, that's section 1151.105. Those statutes are different. 351 includes the language that Mr. Odell would have this court graft on to section 1151.105, but it's not there. So the only conclusion we as officers of the court and attorneys, like all licensed attorneys, the only conclusion we can draw from that is that it was on purpose. If that language was intended to be in section 1151.105, it would be there. And that's really the entire argument that Ms. Browning makes. Their entire argument is that we have to construe subsection B to be limited to the circumstances of subsection A, just like in Estates Code section 351. But that's not what the statute says. And so we can accept Mr. Odell's and his client, on behalf of his clients, interpretation of it, or we can apply the traditional statutory construction principles that and presume those words were omitted for a reason. And when we do that, it's very clear that Mr. Dickens and the other plaintiffs in this case do have standing. There really is no question whether they are interested persons, as that term is defined. The accounting that Ms. Browning filed of this estate lists these plaintiffs as persons with a claim against the estate. By definition, that makes them interested persons. So my clients are interested persons. They are authorized under subsection B to bring that suit or this suit as an interested person. Now, at the end of the day, ultimately, my clients will be required to prove by a preponderance of the evidence what the damages are. And it may be that the court orders those damages paid to the estate versus paid directly to the plaintiffs. Well, if that's the case, so be it. that doesn't make any difference in terms of the standing argument. Mr. Dickens would tell you, if we get into the evidence, that if that money is paid, whether from the guardian or from the guardian's bond, that's a better situation than the money coming straight out of the money that's for the care of the incapacitated ward, Stacy Browning. So whether the money flows directly from the guardian and the guardian's bond to the plaintiffs, or it flows from those parties to the estate and is then available to satisfy the plaintiff's claims, that's really a matter for another day. And frankly, that doesn't determine whether this statute allows my clients to have standing. They are an interested person. The guardian and the sureties on the guardian's bond are liable on the suit of any person interested in the estate. We meet that definition, no question, for the use of the estate, the amount of the claims, or the value of the property. And again, I won't repeat this a dozen times, but one more time will be the last. If the legislature intended to condition subsection B or limit it to subsection A, that's what they would have done, because they did it in the same recodification in another section, and they didn't do it in this section. We cannot presume that was just a slip of the literary tongue, so to speak. That was just some kind of mistake. We have to presume that was intentional. So, Your Honor, with that, I believe so much of the argument appeared to be devoted to the idea of whether my clients are trying to convince Ms. Browning to collect a claim on behalf of the estate, but that simply is not relevant to the standing analysis. The evidence, it's correct, we haven't presented evidence that Ms. Browning has failed to go out and collect claims that are due to the estate, because that's not the case. The case is that she has failed to use ordinary diligence. That has caused damage not only to the estate, but to my clients. That is sufficient for standing. And Your Honor, the motion to dismiss, or excuse me, the plea to the jurisdiction should be denied on that basis.
All right. Thank you, Mr. O'Toole. Mr. Odell, it's your motion. Therefore, you will be given an opportunity for some rebuttal. Do you have any?
Yes, Your Honor. First, let me just address a couple of things Mr. Wymore said. And all I know, Your Honor, is when I received the email yesterday from the court with the pleadings, when I pulled up the pleading that dealt with the response, or what was supposed to be the response to the plea of the jurisdiction, what came up for me was actually a motion, the response to the motion for sanctions. And in fact, the email Mr. Wymore referenced sending to Ms. Phipps yesterday regarding his plea to the jurisdiction, or response to our plea to the jurisdiction, does not actually contain a file marked copy. However, I did pull up the email that Mr. Wymore just sent out to the parties today, and I do show that it was filed. So my apologies, Your Honor, based on what I saw yesterday was where that comment was coming from. As far as Mr. Wymore's comments regarding when this all became clear as to what they were suing for, certainly I cannot dispute, and I don't believe I misrepresented anything to the court as to when that became clear. As I stated in pleadings filed after the petition, it became clear. However, my motions that are before the court today are motions that were filed prior to anything else filed by the plaintiffs, and therefore any clarity that came out was after the filing of my motions, Your Honor. So let me just start off with that. As to the argument made by plaintiffs in response to our motions, again, and I don't want to belabor the issue here, but you know, even if, Your Honor, the language doesn't contain, even if paragraph or subsection B does not contain the specific reference to subsection A, the language of the statute is clear, it states that the amount of the damages that the guardian and the sureties on the bond would be liable for are the amount of the claims or the value of the property that has been lost due to the guardian's neglect. Okay. Well, subsection A specifically provides that the guardian is supposed to use ordinary diligence to do two things. One, collect claims or debts owed to the ward. Or two, recover property that is specifically owed or titled to the ward. Those are the two things the statute requires the guardian to use ordinary diligence. That's the exact amount of how you calculate damages if he or she fails to use that ordinary diligence willfully. And so B specifically references how you calculate damages when A is not complied with. To argue that somehow this has been changed from section 772 of the probate code, where it's been in place since as early as 1995, to now being some sort of, hey, judge, we can come out and just sue the guardian on whatever the heck we want. We'll just come up with something and we'll just say willfully neglected to use ordinary diligence. That's not what 1151-105 provides. Okay. Looking to the predecessor statute indicates that to be the case. Now, if you look to the predecessor statute of the probate code, or the predecessor statute of the personal representative section, which is probate code section 233, the court will note that 233, which I've also provided to the court and the parties, contains a whole lot more than what probate code section 772. There was a whole lot more redrafting in the codification changes that were needed to section 233 than what there was to section 772. It's clear from prior statute 772 and from the language of section 1151-105 that B provides the court with the method and manner to determine damages when the guardian willfully neglects to use ordinary diligence to collect claims owed or recover property that is the ward's. That's what it's about. These parties aren't suing for those reasons. They can't show an injury in fact on account of this cause of action that they're asserting. They can't show that any injuries the plaintiffs have incurred are traceable to an injury or the actions of my client. And third, they can't show that what this court would grant as any way to redress a cause of action under 1151-105 will go to the damages that they seek. And for those reasons, they don't have standing. For the same reasons that this claim is one in which they have not pled facts from their petition, and to the extent that the plea to the jurisdiction is not granted, then that provides that this court has the right to dismiss this lawsuit for a failure to state a claim upon which relief can be granted pursuant to Rule 91A. Again, I'll state to the court that to the extent the court grants the motion under Rule 91A, we would seek authorization from this court to submit an affidavit showing our reasonable and necessary attorney's fees and costs, and ask for the court to grant such fees and costs. And thank you, Your Honor.
All right.
Judge.
Your Honor, may I address one? There was something misleading said there. May I have a maximum of 1 minute to address something?
No, thank you. We're going to go to the next matter, which is, as I understand the suggestion of the parties, the court will take up and hear Defendant Hicks pleas to the jurisdiction, and I recognize Ms. Crouch.
Thank you, Judge. Again, Amanda Crouch on behalf of defendant Judge Dan Hicks. Factually, Mr. Odell laid out how this case originally came to be. It arises from guardianship that has existed for the benefit of Stacey J. Browning's person and estate since the 1980s in Scurry County, Texas. Now, my client, Judge Dan Hicks, became the county judge of Scurry County on January 1st of 2019, and first became aware of this case in May of 2019, when he was contacted by letter from the plaintiffs advising that they were concerned about the ward and the use of the estate property that Mr. Odell described. That letter, Judge, is attached to our plea as Exhibit A, and I pointed out because it doesn't ask for any sort of relief. The plaintiffs didn't file any sort of motion. They didn't ask the judge to enter any order. All it says at the end is, my client and I are available to travel to Scurry County for a hearing, so you may be provided with a more thorough analysis of the matter at hand. That letter, Judge, did not, again, request any legal relief, did not include any motion. Plaintiffs never filed anything of that sort. All they did was ask Judge Hicks to look into the issue because they were concerned. And he did. The next day, and this is attached to our plea as Exhibit B, the very next day, Judge Hicks responded to Mr. Wymore by email and said he would look into this and give him an answer soon. Thank you for your patience, it says. Now, 2 weeks later, the plaintiffs followed up by email and again said that they believed a hearing was the best course of action. But again, they did not request any relief. They didn't file any motion. They didn't ever formally or request to set a hearing. They just sent this email and did nothing further. Now, 2 months later, in August of 2019, or I guess rather 3 months, plaintiffs filed a motion to intervene in the estate. And at that time, Judge Hicks transferred the matter to the district court as he's permitted to do by the Texas Estates Code. And that, Your Honor, was it regarding Judge Hicks' involvement. That was it regarding the correspondence between the parties. That's it regarding any interaction that plaintiffs had with Judge Hicks. The letter, the response email, and then plaintiffs' reply email. On that basis, Your Honor, the plaintiffs have sued Judge Hicks, claiming that his failure to live up to their expectations of what he should have done was somehow a violation of Judge Hicks' obligations under the Texas Estates Code. The plea to the jurisdiction should be granted and plaintiff's claim should be dismissed because at all times, Judge Hicks was acting within his judicial capacity. And as a result of that, as the court knows, he's entitled to absolute judicial immunity, unless an exception to that immunity or a waiver of that immunity applies. Now, the waiver that the plaintiffs assert here, Judge, is Texas Estates Code 1201.003. And that waiver is not applicable in this case, and I'll get into that here in a moment. But as the court knows, judicial immunity is broad and absolute. As cited in our plea, Judge Hicks enjoys absolute judicial immunity from liability for any judicial act. And the case law, Judge, goes so far to say no matter how erroneous the act or how evil the motive, unless a waiver or exception applies. Now, I'm not saying, and Judge Hicks is not saying that there was any ill will or evil motive here. I'm just pointing that out for the court because I think it's important to understand just how broad judicial immunity is and how courts have treated that under Texas law. Now, it's not really disputed, Your Honor, that everything Judge Hicks did related to this case was strictly in his capacity as county judge. The letter that the plaintiff sent was addressed to Judge Hicks. They addressed it to him as county judge at the courthouse. And there are no facts, and the plaintiffs have not pled in their response that Judge Hicks' actions related to this case were not judicial. In that sense, Judge, there's no question that the alleged acts that form plaintiff's claims against Judge Hicks arose in Judge Hicks's official judicial capacity. And so then again, we get to that absolute judicial immunity unless a waiver or exception applies. Now, going back to the judicial immunity waiver that exists in section 1201.003, plaintiff's response that was filed around 5 o'clock yesterday misuses and really misstates that waiver. The response that was filed yesterday says, while judges typically have a lot of discretion, the estates code in this case takes away said ordinary discretion to make sure those that cannot take care of themselves are protected. Your Honor, that's not what section 1201.003 says. And I emailed a copy of the section to the court, but what it says is a judge is liable on the judge's bond to those damaged if damage or loss results to a guardianship or a ward. So that's the first important phrase I want to talk about. Damage or loss results to a guardianship or ward because of the gross neglect of the judge to use reasonable diligence and the performance of the judge's duty under the subchapter. The two important parts of that statute, Your Honor, are the damage or loss results to a guardianship or ward, and then the phrase gross neglect. And I want to talk about those 2 points here separately. The first part, plaintiffs have not and cannot prove that damage or loss resulted to the guardianship or the ward. As Mr. Odell discussed, the damages that plaintiffs seek in this case are for damage that allegedly occurred to their property. And that is their property that is separate from the guardian or the ward. The plaintiffs have no interest in the estate property. They are not related to the guardian or to the ward. They're really unrelated third parties. And so they don't meet, Judge, the standard of 1201.003 to prove that damage or loss resulted to a guardianship or a ward. That is not the basis of their claims in this case, and there's nothing in the allegations that they've made that would rise to that requirement. The second part, Judge, plaintiffs have also not pled sufficient facts to establish gross neglect. As the case that is cited by both Judge Dan Hicks and the plaintiffs say, James versus Underwood, gross neglect requires a level of want of care to rise to conscious indifference to the right or welfare of the person or persons to be affected by the conduct. I'm looking at page 13 of the second amended petition, Judge, and that is plaintiff's own definition of gross neglect. They have to show that Judge Hicks did not care and exercised and showed conscious indifference to the rights of the guardian or the ward. And there's no evidence, Judge, in the record of rising to that level. And the plaintiffs rely on Johnson versus Dexel, which is cited in their response. It's a federal case applying Texas law. In that case, recognizes and actually found that the waiver of immunity did not apply because the judge's actions did not rise to the level of gross neglect that's required by the statute. What Johnson says is what separates ordinary negligence from gross negligence is the defendant's state of mind. In other words, the plaintiff must show that the defendant knew about the peril, but his acts or omissions demonstrated that he did not care. There is nothing in the record, Judge, that shows that Judge Hicks did not care. Plaintiffs allege that the judge's failure to act on a motion could support a finding of gross neglect. Even if that proposition was true, Judge, which it's not by the plaintiff's very own authority, those are not the facts before this court. There was a letter sent, a response, and a follow-up email, and that is it. There was no motion. There was nothing for the court to actually rule on. The plaintiffs offered to have a hearing, but on what? There was no relief actually requested. And at that point, anything that Judge Hicks would have done would have been essentially a sua sponte advisory opinion, which is not what's required or frankly what's permitted as a judge. And that's important, Your Honor. It's important because filing such a motion or asking for some sort of judicial relief would require the plaintiffs to have standing. As has already been determined, they did not have standing to intervene in this case, which is frankly why they probably sent the letter that they did as opposed to filing some sort of a motion. Either way, their actions, or Judge Hicks' actions in response simply don't rise to the level of gross neglect that the law requires. I think it's important, Your Honor, to point out that plaintiffs have failed to cite any case to this court where the waiver of immunity was actually invoked under 1201.003. I'll represent to the court that I have looked for those cases and I have found none. And I believe, Judge, it's because that judicial immunity is so absolute and so broad that the circumstances where judicial immunity is permitted to be waived are few and far between. And they definitely, the facts of this case definitely do not rise to that level. Plaintiffs somehow want the language of their initial letter to magically constitute a requirement for Judge Hicks to do what they wanted him to do, and claim that the absence of that constitutes gross negligence. That's just simply not the law, Your Honor. Simply, I believe plaintiffs wanted to use Judge Hicks to somehow provide some support for their claims in Williamson County. But their claims of what Judge Hicks should have done, as referenced in paragraph 23 of their response, does not somehow make these allegations the law, and does not make Judge Hicks' actions rise to the level of the waiver of immunity under 1201.003. Judge Hicks is not claiming that he's immune to responsibilities, Your Honor, but his actions simply do not rise to the level of gross neglect that the statute requires. For those reasons, Judge Hicks has absolute judicial immunity that has not been waived. This court should grant Judge Hicks' plea to the jurisdiction, and he should be dismissed from this lawsuit. Thank you, Judge.
Yes, ma'am. Mr. Wymore or Mr. O'Toole, who's going to respond?
Judge, I'll take this one. I'll tell you, just at a fundamental human level, I think that there is some degree of sadness to what we're dealing with here, Judge. And I'll tell you why. In 2018, Mr. O'Toole and I filed a lawsuit on behalf of our clients because the gun range operating on Stacy Browning's property was shooting hundreds of bullets onto our client's property. And we had a hearing in Williamson County in December of 2018. Shortly thereafter, Judge Rick Kennan issued his decision and said that he's granting our request for relief, sans handguns, because Judge, ultimately the evidence that we presented showed that the ability of handguns to cause bullets to reach the property is very, very nil. And it was also consistent with the Range Protection Act. In February of 2019, competing orders were submitted to Judge Rick Kennan. And in those competing orders, both parties admitted, and Judge, this is the order that was submitted by Ms. Browning's attorney, or attorneys in Williamson County, said the range in its present condition presents a significant risk of harm to life. In February 2019, Ms. Browning's attorneys submitted an order that says the range in its present condition presents a significant risk of harm to life. They knew it did. But you know what they did, Judge? They kept operating it. The sad part is, from 2018 into the spring of 2019, Stacy Browning's identity was concealed. So Mr. Dickens finally reaches the point where he says, you know what? I can't believe they're still doing this. They're putting this guy's property at risk. So he sends him a letter. And only through Mr. Dickens' own efforts and our efforts was it discovered that Stacy Browning is a ward. So in May of 2019, Judge, here's what we know. We know that the judge in Williamson County has entered an order, has issued a decision, and Pam Browning, through her attorneys, represents that the range in its present condition presents a significant risk of harm to life. So we tell Judge Hicks those things. So here's the question, Judge, and this is where these issues are divergent. I think Judge Hicks, Ms. Browning, and their respective counsel would like to paint this thing as a pure financial transaction, but it's not. I would submit the problem with the hearing that we had last November was that this thing was cast as a financial transaction, but it's not. The unequivocal record from February of 2019 on is that everyone admitted. Because in Williamson County, Mr. Wentworth and Ms. Salinas submitted an order on behalf of Millard, Grantham, Best of the West Shooting Sports, and Pam, all admitting the range presents a significant risk of harm to life. And we knew that. We knew that. That wasn't in dispute, but they kept operating. So we told Judge Hicks, Ms. Crouch would like to cast this as Judge Hicks just getting a letter and an email and, well, gosh, they really didn't request any type of formal relief. That they just didn't quite meet that standard. That's not what happened, Judge. We didn't come in with a hammer and hit anyone over the head in May of 2019 and say, the world needs to be obliterated. We need to blow up this guardianship. Well, no, what we first tried to do is have a conversation. We tried to present those issues. And you know what he did? Nothing. He ignored us. Between May 15th of 2019 and August 9th of 2019, after we had told Judge Hicks that this range has been admitted to present a significant risk of harm to life, he did nothing. Not a dang thing. 87 days that the range continued to operate in direct violation of what it is that Judge Rick Kendon said, and in a manner that they knew constituted risk of harm to life. So finally, we filed a motion to intervene. Well, Judge, that just absolutely obliterates the argument that Ms. Crouch made that we didn't ask for any type of relief because, gosh darn it, we sure did. That's what the motion to intervene was. So, well, okay, the more informal communications, those aren't going to work. So let's get something formal on file. Let's file a motion to intervene so that we have standing to tell the folks in Scurry County that the range is still operating in a manner that presents a significant risk of harm to life. Let's tell them that Judge Rick Kendon said you can't shoot rifles anymore because those rifle bullets are leaving the range property and they're entering other properties. Or let's tell them, those folks in Scurry County, let's tell them that the proposed orders submitted by both parties have now been entered by Judge Rick Kendon said that the range presents a significant risk of harm to life and property to people traveling on the train tracks and on County Road 206. Well, surely they're going to want to hear that. Surely they're going to want to hear that this range is continuing to operate. Well, Judge Hicks, he punted. He sent it up here to you. And then we had a hearing last November. And Judge, at that hearing, we admitted into evidence that proposed order that the range that Ms. Browning submitted in Williamson County, where she admitted the danger that the range presents. In opening arguments, Mr. Odell made the argument that the operation or that the lawsuit in Williamson County is hotly contested. Judge, I want to juxtapose those two things. In February of 2019, an order was admitted by Pam Browning in Williamson County admitting the range is dangerous. Not only to my client, but people traveling on a county road and people traveling on train tracks. Yet at the same time, just a few months later, Mr. Odell says it's hotly contested. So riddle me this. Why is the estate hotly contesting something that they've already admitted is dangerous? And by the way, Judge, when we were in your courtroom last time, I asked Ms. Browning a question. I said, continued rifle fire of any benefit to Stacy? She said no, probably none. So they admitted it's dangerous. Mr. Odell said it's hotly contested. And then Miss Browning admits on the stand that the continued rifle fire is of no benefit. Whether or not we can prevail in Williamson County is very different from what we're looking at in Scurry County. And here's why. Because in in Williamson County, we put on evidence, and that evidence, if someone would ever bother to look at it, clearly indicates that they've got to make the range safe. That's what they have to do. If Millard Grantham owned this property, if Pam Browning owned this property, and they wanted to make a safe range, they could. They could make an outdoor range. They would probably have to invest 7 figures in it, but they could make a safe outdoor range. And you know what that would mean? That would mean there would be some degree of risk of bullets escaping. That's just what the law tolerates. But we're not dealing with that here. Judge, what we're dealing with is folks trying to continue to operate a gun range that has been admitted to be of no benefit to Stacy. This is profiting off of the estate. And we tried to get all of this into evidence last November, but the argument was, the parties limited the scope of the hearing. Well, no, we didn't, Judge. We didn't. We said we would deal with intervention and leave the issue of removal for another day, but that was the basis of limiting evidence. Judge Hicks should have wanted to hear what was happening down there. This court should have wanted to hear what was happening down there. Because up here in Scurry County, there's only one person that needs to be focused on, and that's Stacy. But here's what happened. About a decade ago, the estate loaned hundreds of thousands of dollars to Millard to build this range. Well, actually, they loaned it to Millard and Billy Ray Browning. And then they built their range. Hundreds of thousands of dollars are still due on that loan. Judge, you and I couldn't get a deal like that. No one could. And then they operate this range and they say, you know what? We're going to let old Millard lease this thing for $1,600 a year. Come on down to Central Texas, Judge, and try and find a business deal where you can lease a sufficient amount of property to operate a gun range right off of a major state highway for $1,600 a year. And oh, by the way, the landowner, they're gonna finance the construction and operation of that gun range for a few $100,000, and you're gonna have at least 20 years to pay it back. That's not a deal anyone could ever get. That's not in Stacy's best interest. If all else were not considered, what should have been considered is the moment that Pam Browning testified last November that the firing of rifles is of no benefit to Stacy. It should have been shut down. So in looking at the claim against Judge Hicks, what does 12-01-00003 say? A judge has the duty to exercise reasonable diligence to timely decide or promptly hear a motion raising well-founded concerns about a ward's condition or guardian's duties. The judge's failure to act on a motion could support a finding of gross neglect. That's cited in the Estates Code and also in the Johnson v. Dexel case, 373 Fed 3rd 764, imposing the duty to promptly hear and investigate. So I'll pose the question. We told him that the judge in Williamson County made a decision shutting the range down. And we told him that the parties admitted the range was unsafe in its present condition. And we told him that bullets were coming on our property. He did not. We offered to come here, have a hearing. But his response is, well, no, we didn't receive a motion or the pleading that specifically requested relief in the manner that he deemed prudent. So let's illustrate the absurdity of that. Let's say Judge Hicks received a letter from someone that said, hey, Judge Hicks, and this is just Joe Blow off the street. Judge Hicks gets a letter that says, Judge, Pam Browning just cut me a check for $150,000 for the estate for nothing. Would his response be, well, that didn't come in the form of a motion? I mean, it's concerning, but I'm not going to look into it because it didn't come in the form of a motion. No. Gross neglect is the entire want of care or conscious indifference to the right or welfare of the person or persons affected by the conduct. So we told him. The parties admitted the range is unsafe. Even though they admitted it's unsafe, they're continuing to operate it, and they're continuing to shoot bullets on our property. For 87 days, he sat on that knowledge, and he did nothing. He knew what we told him. And after he kicked it up to this court judge, this court had the information at its disposal. When Judge Hicks transferred our motion to intervene to this court, the range was still operating, despite the knowledge that it presents a significant risk of harm to life. Is the injury traceable? It certainly is. It all comes back to what I've argued before. There's a significant risk of harm to human life. Can it be redressed? Absolutely. The judge is liable on the bond. The cases that we've cited, the Underwood case and the Dexel case, clearly state that that's true. I want to walk back to some of the arguments that Judge Hicks made in his plea to the jurisdiction. Sections 2 and 3 of that plea to the jurisdiction are devoted to the general idea of judicial immunity and how at all times Judge Hicks was engaging in judicial acts and, as his counsel argues, protected by immunity. They correctly cite the law, but the law has nothing to do, that, at least insofar as the facts of this case apply, it's obviated by section 1201.003. What the Underwood case does is it builds upon itself. When they look at these cases, specifically the Underwood case, the reason that 1201.003 didn't attach is because at the time the acts were complained of, there wasn't a guardian. A guardianship estate is a three-legged stool. You have to have the ward, the guardian, and the judge. And if you take out one of those, components, you don't have the proper parties. So only when there was a guardian could those duties under 1201.003 attach. But they hadn't. In this case, they had. This is what's more perplexing, Judge. Why wasn't this issue initially revealed? Why didn't the folks in Williamson County tell us, hey, Stacey Browning's a ward? And I mean, of course, those communications down there between Pam and the attorneys in Williamson County are protected by attorney-client privilege. But gosh, I mean, you would think that the paramount thought would be, this is all about Stacey, which it should be. Someone should say, we're operating a gun range on his property and we're shooting bullets onto other people's property. We're exposing the estate to risk. Someone should have wanted to tell Judge Hicks, wanted to get him involved. Take some affirmative, proactive action to look after the only guy that we ought to be considering here. But instead, we're sitting here today, mired down and bogged down in a bunch of procedural minutia instead of cutting through the clutter and saying one simple thing. A gun range on Stacey Browning's property is of no benefit to Stacey, and regardless of whether or not anyone believes plaintiffs can prevail in Williamson County, the right thing to do in Scurry County is to say, folks, you got to stop this. Because we've already put on a case in Williamson County, and we've been told that we're likely to prevail and that the range presents a significant risk of harm to human life. I mean, that really ought to be the only thing that we're factoring in here today. But sadly, we're not. Every time that we've come to Scurry County, and I sincerely hope the outcome is different today. I hope this court wants to listen. I hope it is interested in a full and thorough understanding of the utter neglect to care for Stacey. I hope the depths of the lack of concern for leasing property for $1,600 a year, knowing bullets are leaving that property and saying, yeah, we don't care. I hope that sinks in. The response that we filed in more thorough detail lays out the issues of traceability, redressability, and standing in general. In looking at these pleadings, this court is to construe our pleadings liberally. This court is to take all factual assertions as true, and this court is to look to the plaintiff's intent. In doing that, we have set forth a claim not only on 12-01-003, but also on 11-51-105. It's time that we stop looking at this as a financial transaction and looking at it for what it is. This matter should have been stopped a long time ago. And we stated in some of our pleadings filed yesterday, you know what, if someone would have said in the middle of 2018, gosh, this isn't safe for Stacey, we're going to shut this down. This case probably could have been settled for a temporary or for a permanent injunction only. But here we are. Mr. Odell saying it's hotly contested, even though it's unsafe. Someone needs to stop looking at this as a financial transaction and look at it for the benefit of Stacey. Thank you.
Mr. Crouch, you are the movant. You may have rebuttal.
Thank you, Judge. I have 4 points, and I'll try and make them brief. First, as you just heard from Mr. Wymore, the plaintiffs had an order in 2018 from Williamson County. They had the relief that they needed. And if they had issues with that order, if they contended that the range was still not operating safely, their remedy, Judge, was to go to Williamson County and ask the court to enforce their order. And you didn't hear from Mr. Wymore that happened. But at that point, they had an order. If they felt like that order was being violated or was not being followed, their remedy was to go back to the Williamson County judge and ask the court to enforce it. Your Honor, there was also some argument about concealing Stacey Browning's identity. As it relates to Judge Hicks, and I want to bring us back to that point because I think a lot of what you just heard from Mr. Wymore is not related to the actions of Judge Hicks in this case. But as related to Judge Hicks and to this plea, there's no evidence that Judge Hicks did anything to conceal Stacey Browning's identity. Judge Hicks was not county judge until January of 2019. By that time, the plaintiffs already had obtained relief from Williamson County. Notably, Judge, in the letter that was sent to Judge Hicks on May 15th, Mr. Wymore describes for the judge that what Mr. Browning's identity was. I mean, there's just no evidence that Judge Hicks, to the extent that anyone concealed Stacey Browning's identity, and that's not what I'm contending because I don't think that's correct. But to the extent that that happened, there's no evidence that Judge Hicks had any part in that. Judge, there's no obligation of Judge Hicks under the law to report back to these plaintiffs. The plaintiffs are a non-interested third party. They have no interest in the estate. They have no interest in the guardianship. The plaintiffs wanted Judge Hicks to provide some report back about his investigation, and there's just no obligation of him to do that under the law. The plaintiffs didn't point to any sort of statute that requires that, and that's because there's not one. There was also some argument about what Judge Hicks should have wanted to hear. And although plaintiffs may not like it, that is not the law. The law puts in place what Judge Hicks is required to do. He has judicial immunity for those actions, and that is absolute unless a waiver applies, and it does not here. To my second point, Judge, on the motion to intervene, Mr. Wymore said that motion, quote, obliterated my argument. And that's not accurate. That motion to intervene was filed in August of 2019. If that's the motion that the plaintiffs contend should have been heard, it was. It was transferred to this court as Judge Hicks was permitted to do under the Estates Code. And for that matter, Your Honor, the first amended petition that was filed that added Judge Hicks as a defendant was filed a mere month later. It was filed in September. Judge Hicks did not exercise gross neglect in transferring that motion to the district court. He's permitted to do so, and he did so under his rights under the Estates Code. So to the extent that motion to intervene is what the plaintiffs are relying on to prove gross neglect, that is just not accurate. To my third point, I believe the motion argument misconstrued the argument that I was trying to make. I'm not saying, and Judge Hicks is not saying, that a motion is required for there to be action taken under the Estates Code. I believe plaintiffs are oversimplifying and misconstruing the authority. The language of Dexler is not absolute. It says that a judge may hear a motion and it could take action, but it never says that the failure to take action is the automatic waiver of immunity that plaintiffs want here. And Judge Hicks didn't fail to take action. He just didn't take the action that the plaintiffs wanted. That also doesn't waive the absolute judicial immunity. Your Honor, plaintiffs' counsel indicated that we're here on procedural minutia. I would disagree wholeheartedly that absolute judicial immunity constitutes procedural minutia. It's a protection that's imposed upon judges by decades of law to protect the integrity and the efficiency of the judicial system. And Judge Hicks is well within his right to make that argument in response to the claims the plaintiffs have made here. And finally, Judge, whether or not the plaintiffs can prevail in Williamson County, you heard, I believe, counsel say that whether they can prevail in Williamson County is different than the remedies available in Scurry County. In Williamson County, Judge, their relief, as I understand it, is they want the range to be made safe. And if the range is made safe, then I would pose the question of whether that resolves the complaint that the plaintiffs have that it's dangerous. At this point, the range is closed. It has been since September of 2019. And really, that judge has nothing to do with the facts that are before you today on the plea to the jurisdiction. There's also been a lot of argument about these orders that were submitted. Again, Judge Hicks had nothing to do with that process. He didn't submit any orders as part of the Williamson County dispute. He frankly wasn't even county judge at the time. But to the extent that those orders are being represented as admissions by the parties, I want this court to understand that context in which they were submitted. they were submitted as competing orders after the Williamson County Court granted the preliminary injunction. And so those orders were drafted to support a preliminary injunction after it had already been ordered. If it wouldn't have said, or if it would have said there was not a significant risk of harm, then it wouldn't have supported the preliminary injunction. So I just want to make sure the court fully understands that context and is not misled by what that order meant or was supposed to mean. Simply put, Judge, nothing that you've heard here today, nothing that you've seen in the pleadings rises to the level of gross neglect that the plaintiffs have to prove to waive absolute judicial immunity. And for that reason, we would again urge the court to grant Judge Hicks' plea to the jurisdiction and dismiss him from this proceeding. Thank you, Judge.
You're welcome. That leaves us with the defendant Browning's motion for sanctions and the plaintiff's motion to dismiss the motion for sanctions pursuant to TCPA. I have read those motions as I have read all of the motions. I will allow Mr. Wymore or Mr. O'Toole, whoever is going to handle that part of it, to proceed. I believe that's Mr. Wymore's contention that that should be heard before the motion for sanctions. If that is, in fact, the contention, I will allow that, Mr. Wymore or Mr. O'Toole, who's going to present that.
I will, Judge. Thank you.
Right. You're welcome.
So an action that infringes on a person's right to petition is a SLAPP action, and there is case law that supports the position that a motion for sanctions is a judicial pleading or filing that requests legal and or equitable relief and thus implicates the Citizens Participation Act, initially cited at the Hawkshurst case, 550 Southwest 3rd, 220 at 226. That was before the amendment. However, Judge, there is a subsequent Third Court of Appeals opinion issued in 2020 following the amendment that reiterates that point that a motion for sanctions does in fact implicate the Citizens Participation Act. So under the law as it presently reads, a legal action is a filing that requests legal, declaratory, or equitable relief. While that does not include a procedural motion, if the motion does in fact add a claim for legal, equitable, or declaratory relief, then it does implicate the Citizens Participation Act. This is Civil Practice and Remedies Code 270016. That makes that reference to the adding of a claim for legal or equitable relief. What it says is a court shall dismiss a legal action if the non-moving or if the moving party demonstrates the legal action is based or in response to the right to petition. That's 27005B. So when you look at Ms. Browning's motion for sanctions, formally, when a party files a motion for sanctions, and Judge, I did exhaustive research on this, you are by and large dealing with sanctions within the context of discovery reviews. Those are the overwhelming abundance of appellate opinions that we deal with. But what Ms. Browning has asked for is death penalty sanctions and other relief. If you take a look at her motion for sanctions, she asked this court to dismiss the original petition with prejudice. I will presume that that only means the original petition insofar as it pertains to Pam Browning and not the other two defendants in this case. She also asks that this court issue an order directing plaintiffs to refrain from any and all contact with Pam Browning, Stacy Browning, or any member of her family directly. That is effectively asking Judge for one, injunctive relief, or two, a protective order. The other thing, incidentally, I'll point this out, Judge. It was the subject of our prior motion for sanctions. I would question the legitimacy of such an order. I know that Mr. Dickens was previously sanctioned for violation of what is tantamount to Ethics Rule 4.02, which prohibits attorneys from contacting represented parties, but comment 2 to Ethics Rule 4.02 that was Mr. Dickens was previously sanctioned for expressly allows the communication written or otherwise between parties. So I would think that there would be it would be a very tenuous position to put the parties in. Ms. Browning also asked that this court issue an order directing plaintiffs and their counsel to pay all of Ms. Browning's legal costs, including court costs, attorney's fees, and expenses, including in bringing her plea to the jurisdiction, motion to dismiss, and motion for sanctions, and further in a very broad and general manner in order to assure plaintiffs understand the impropriety of their actions and order to pay a penalty into the court. It's 4 different subparts, but Judge, this goes beyond saying plaintiffs have failed to respond to discovery. The law allows for a motion for sanctions for a party that engages in discovery abuse. And this is ultimately asking for a final determinative decision as to the merits of this case. They want to skip the process where we actually had a hearing, a trial, I should say, where the parties exchange evidence. The court has occasion to offer and receive and consider all of the evidence and all of the different arguments and the different legal merits. And they're simply saying, Judge, we want you to take a look at the lawsuit that plaintiffs filed and our motion for sanctions, and thereafter summarily dispose of everything. And oh, by the way, also ask them to pay us, pay the court, and tell them that they can't contact these certain people. Those are requests for legal and equitable relief that implicate the Citizens Participation Act, because again, any judicial pleading that requests legal, declaratory, or equitable relief implicates the Citizens Participation Act. And that is what Ms. Browning has done in her motion. I won't belabor the previous factual arguments that were made when Mr. O'Toole was arguing against Ms. Browning's plea to the jurisdiction, nor will I reiterate what I argued in responding to Judge Hicks' plea to the jurisdiction. In looking at the case law that is cited by Mrs. Browning, she relies on one case. Primarily, it's Barnes v. Kinzer, 600 Southwest 3rd 506. And that is a Dallas Court of Appeals case that addressed the Hawkshurst case out of the Third Court of Appeals and said a motion for sanctions does not constitute a legal action under the Citizens Participation Act. Ms. Browning also argues that the Misco case, 575 Southwest 3rd 872 out of the Dallas Court of Appeals supports that opinion. And essentially, Judge, what happened in the Misco case, there was a discovery dispute. And after there was that discovery dispute, one of the parties filed a motion for sanctions. And then in response, the party that was the impetus of the discovery dispute filed a motion to dismiss under the Citizens Participation Act. The result of it was that the Dallas Court of Appeals said that's a motion for sanctions over a discovery dispute, asking them to have to do what they've got to do and then pay attorney's fees. That qualifies as a procedural motion. Ms. Browning also references the Patel case out of the 14th Court of Appeals, not cited in any of the reporters, 14-18-00771-CV or 2020 Westlaw 2120313. What that case said, what that court said, is that appellate in the Patel case, The appellee's sanction request was not a legal action that implicates the Citizens Participation Act, because the Citizens Participation Act refers to a legal action in a sense of a procedural vehicle for vindication of a substantive right. They ultimately made the decision that in the Patel case, the motion for sanctions did not make a request for legal or equitable relief. And so what they said is, we're going to decline to expand the Third Court of Appeals reasoning. But they didn't say that the reasoning was wrong. They just simply made the very clear and nuanced point that if you're going to file an anti-SLAPP motion in response to a motion for sanctions, it has to be a motion for sanctions that implicates the Citizens Participation Act, i.e. a motion that seeks new additional legal and equitable relief, like what we're dealing with here. Looking back at the Barnes case, what they said, the Dallas Court of Appeals, is that Barnes failed to establish that the counterclaim for sanctions is a legal action, because the request for sanctions here is not a request for legal or equitable relief. Again, it didn't expressly rule out the idea that a motion for sanctions can't implicate the Citizens Participation Act. Ultimately, we can also get you the case on that other Third Court of Appeals case. What the Citizens Participation Act then holds is that a court may not dismiss a legal action if the party bringing the legal action establishes by clear and specific evidence a prima facie case for each essential element of the claim in question. Well, in looking at that additionally, this court may only consider a response from Ms. Browning that meets the requirements of Rule 166A. In other words, an anti-SLAPP response is limited to what effectively a summary judgment response is. You file your response at least 7 days before, you can attach evidence, you can, most importantly, attach an affidavit. But there's got to be 166A supporting evidence. That standard requires Ms. Browning to offer at least some evidence. But she didn't. She didn't. She offered no evidence. What Ms. Browning asks for is for plaintiffs to be sanctioned on the basis of their pleadings alone. You can't do that. Under Rule 13, you got to show that a pleading is not only groundless, but also brought in bad faith. And a petition alone cannot establish that an action was brought in bad faith or to harass. It is this court's duty to examine the facts available to the litigant and the circumstances when the pleadings were filed. Rule 13 requires sanctions based on the acts or omissions of the parties or counsel, not merely the legal merit of the pleadings. That's cited at 829 Southwest 2nd, 398 at 400. That's from the 14th Court of Appeals. Pam Browning didn't offer any evidence. She doesn't know what the state of mind was or the acts or omissions outside of the pleadings. Mainly because at this point, pleadings were filed and a motion for sanctions was filed. The pleadings or the motion for sanctions doesn't reference anything outside of the pleadings. It just simply attacks and argues against the legal merit. Under Chapter 10, you've got to show improper purpose. And improper purpose has been found to be the equivalent of bad faith under Rule 13. That is cited at 2005 Westlaw 1907126. The party seeking sanctions bears the burden of overcoming the presumption of good faith, judge, which must be pursued. assumed. And bad faith requires, or improper purpose within this context, it requires the showing of a conscious doing of wrong for a dishonest, discriminatory, or malicious purpose. Under Rule 10, you have to show evidence of the party's subjective state of mind before you sanction them. That's 508 Southwest 3rd, 657 and 677. But they offered no evidence. The only way that they could have offered evidence as to Mr. Dickens, Mr. O'Toole, myself, Mr. Atkins, would be to submit an affidavit. Something that this court could properly consider that would show that something here was done for bad faith, for improper purpose, for a dishonest, discriminatory, malicious purpose, something, but none of that was shown. I know I addressed this before, but while this court would normally hold an evidentiary hearing to gain some insight, ultimately, I think that a decision must first be made on this motion. In looking at the presumption of good faith, there has to be something to overcome that. There must be some evidence that points directly to the behavior, the wrongdoing, outside of the pleadings, outside of the filing of the lawsuit, that supports. Last point I'll make is that sanctions are reserved for those egregious situations where the worst of the bar uses our honored system for ill motive without regard to reason and guiding principles. A trial court may not base sanctions solely on the legal merit of a pleading or motion. But that is what, and I'm sorry, that site is 371 Southwest 3rd at 294, 103 Southwest 3rd, 664 at 668. But that is exactly what Ms. Browning is asking this court to do. She is asking this court to sanction solely based on the legal merits of the arguments that have been made. Maybe she doesn't like it, that's fine. Maybe this court doesn't like the argument under 1151-105, but it doesn't make it sanctionable. The purpose of sanctions is to ensure that bad conduct is addressed. The other thing is, when you're looking at sanctions, you not only have to prove that pleadings are meritless, I don't think they can, but you have to also have to argue and prove that the pleadings were not made based on some good faith argument for extension, modification, or interpretation of the law. Well, I think in the plea to the jurisdiction that Mr. Odell argued, what he set forth is an argument against the legal merits of the lawsuit that was filed. And that's a good faith argument, and this court could buy it. But that doesn't mean that plaintiff's argument is not a good faith argument. Again, what happened, and I'll say this is interesting. The old section of the probate code that Mr. Odell cited, or the probate code, it had one big block section. And that big block section said if there's failure to collect a debt and use property, then on the suit of an interested person. But then what they did when the legislature, whenever the Estates Code was enacted in 2014, they actually broke that up into the two separate sections. So the legislature affirmatively did something to segregate and alter what is now section 1151-105. I sincerely hope that this court will take occasion to look at the legal merits of these pleadings, understand the importance of them. I know that in responding to Judge Hicks' plea of the jurisdiction, went over the facts of this case ad nauseum. I think the court should consider all of those factual arguments here. They don't bear repeating, but they are important. this court should not sanction a party for trying to stop something that has been admitted to be a significant risk of harm to human life and of no benefit to Stacey Brown. That's the evidence that was submitted to this court last November. That's the evidence in this record, and that is the fundamental thrust of what is being argued here. Thank you.
Mr. Wymore. Mr. Odell.
Yes, Your Honor, I appreciate it. Again, Brad Odell here on behalf of Ms. Browning. And Your Honor, I'm going to leave my comments to, or my argument to, the actual motion to dismiss pursuant to Chapter 27, because while Mr. Wymore and Mr. O'Toole and Mr. Adkins and I disagree on many things, the one thing I will say I agree with them on is that before you can get to my motion for sanctions, despite Mr. Wymore's arguing it already, you have to rule on the TCPA. I'm a firm believer that you got to follow the law. And so let me go ahead and address that first, Your Honor. And then if you are so inclined to either rule or at least allow for the argument and take all this under advisement, I'll go ahead and present on my motion to for sanctions. Your Honor, I think first and foremost, the important thing to recognize here, Your Honor, is that effective September 1st, 2019, the TCPA was amended and became effective. And in particular, the language describing what is exactly a legal action was redefined by the state legislature. And it provides as follows: legal action means a lawsuit, cause of action, petition, complaint, cross-claim, or counterclaim. And then I'm going to highlight these words here for a second: or any other judicial pleading or filing that requests legal, declaratory, or equitable relief. And then it goes on to say the term does not include a procedural action taken or motion made in an action that does not amend or add a claim for legal, equitable, or declaratory relief. And it has a couple other things that it does not include, but relevant to this motion is, of course, 27.0016A. Now, Your Honor, this statute was amended after the Hicks case, as was cited by Mr. Wymore. It was also amended after multiple cases that had gone up on appeal dealing with what exactly can you do with a TCPA cause or claim motion, and how far does this thing allow for parties to go? Because obviously, as the case law clearly indicates, the intent of the TCPA was to provide courts and parties to a lawsuit that violates a party's right to petition, exercise their right of free speech, and the other things covered by the TCPA, was to allow for parties to quickly and judiciously and inexpensively get rid of those lawsuits and get rid of the costs that these parties were going to incur to fight out a lawsuit when essentially these lawsuits were retaliation. Unfortunately, courts like the Hicks case have taken it too far. And they've allowed for litigants to file motions under the anti-SLAPP statute, or the TCPA, against motions that a party is bringing, in this case, motions for sanctions, because they say that, or they said under the old law, which I think, again, important distinction is the new law clearly distinguishes it. The old law did not have the exclusion language in the definition of legal action. But they said, well, they're seeking some sort of relief based on their request for sanctions. It begs the question, and litigants have filed motions on top of their motion under the TCPA. As I pointed out in my response to the court, to the motion to dismiss under the TCPA, essentially, Ms. Browning, because the plaintiffs asked for sanctions and their own attorney's fees could have filed their own motion to dismiss under the TCPA. But that's not what this statute is about. This statute isn't meant to continue expensive, contentious litigation. Instead, Your Honor, it's meant to take care of claims that are not meritorious whenever someone is retaliating against another party for their exercise of essentially First Amendment rights. And so the legislature made that clear when it modified or amended the statute, and it provided the exclusions in the definition of legal action. I'll also point out, Your Honor, that the statute has said and continues to say that it does not abrogate or lessen any other defense, remedy, immunity, or privilege available under other constitutional, statutory, case, common law, or rule provisions. And Your Honor, that's at section 27.011 of the Civil Practices and Remedies Code, or what we've been referring to as the TCPA. So the statute itself already indicates, before the legislature amended it, that this statute was not meant to abrogate or lessen the rights of the parties under statutes or rules or common law. Instead, it was meant as a method to, again, get rid of the contentious or the unmeritorious litigation that is brought in retaliation to someone exercising a First Amendment right. Now, because the statute has been amended, because it specifically excludes procedural actions or motions taken in an action, which is what we did. We filed a motion for sanctions in the lawsuit originally started by the plaintiffs. This does not constitute a legal action under the TCPA. And because it doesn't constitute a legal action under the TCPA does not authorize the dismissal of our motion for sanctions. Your Honor, even if this court were to look at the prior statute, which of course, as I pointed out in our response, was what the movements primarily relied upon, the case law is conflicted. And with candor to the court, I recognize that the Court of Appeals in the Austin court has allowed for a TCPA action to dismiss a motion for sanctions. However, as was discussed by Mr. Wymore, the Barnes case out of the Court of Appeals in Dallas, the Patel case, likewise, Your Honor, out of this one was out of the 14th District Court of Houston, and the Misco case, again, out of the Dallas Court of Appeals, have all held that a motion for sanctions was not subject to the TCPA under even the prior statute. And I think the reasoning behind the Patel case, and while movements would argue that it's, I guess, not on fours, I think the reasoning, one, I think it is on fours, and two, I think the reasoning is very sound. In that case, you had a lawsuit. In the lawsuit, there was a counterclaim / motion to impose sanctions under Chapter 10 of the Civil Practices and Remedies Code, as well as Rule 13 of the Civil Practices or the Texas Rules of Civil Procedure. And the Patel court said this about trying to understand what is actually a legal action under the TCPA. Neither Rule 13 nor Chapter 10 establish an independent cause of action for damages, right? Rather, they provide a basis for a trial court to impose sanctions or attorney's fees upon motion or the court's own initiative. So, Your Honor, I think that's a very important distinction. I don't have the right, or my client, better said, doesn't have the right to go out and file a lawsuit against the plaintiffs for violation of Chapter 10 of the Civil Practices and Remedies Code, or under Rule 13 of the Texas Rules of Civil Procedure, unless, as is the case here, plaintiffs have already started a lawsuit. And so, because of the fact that these remedies that are granted a defendant in a lawsuit, in response to that lawsuit, the Patel court held that a motion for sanctions, even if put into a counterclaim in a lawsuit, does not constitute a legal action. And they also went in, because again, at the time that they were interpreting the statute, we were dealing with the predecessor statute. They went in and discussed how courts should look at and interpret statutory language. In particular, they stated, when the more specific items, lawsuit, cause of action, petition, complaint, cross-claim, or counterclaim, are followed by a catch-all other, and that was the language I tried to highlight for the court, the doctrine of, and I'm not going to get this right, Your Honor, so I do apologize, but judice generis requires that the latter must be limited to things like the former. And that canon provides when general words follow an enumeration of two or more things, they apply only to things of the same general kind or class specifically mentioned. And they went on to hold that because of the fact that the prior language, the list, the enumerated claims, lawsuit, counterclaim, complaint, because of that language, they held that the catch-all that the Hawkshurst case relied upon and other courts have relied upon to make TCPA Act motions much more prevalent than what they were intended to be, that those should actually be limited to situations in which a substantive cause of action is being brought. And they held that a Chapter 10 sanctions request or a Rule 13 sanctions request, because of the fact that it actually is stemming from a lawsuit, is not a substantive cause of action. In fact, at page 6 of this opinion in Patel, it says, relying on this court's decision cited above, and that was the Misco case, that do not recognize a Chapter 10 sanctions request as a separate cause of action in our previous decision in Roach, we declined to expand the Austin court's holding in today's case. And so this court, the Patel court, as well as the Barnes court and the Misco court, have all held that sanction motions are not legal actions under the prior statute, but even more so under the current statute. And I think, as has been argued throughout this hearing, as we understand what the legislature does, when the legislature specifically amended this statute and excluded procedural motions in the definition of legal action, it becomes evident that the legislature was aware of all the case law going on with the multiple motions under the TCPA, and they were attempting to change that and narrow the statute so that it was clear that under the TCPA, a legal action does not include a motion similar to the one Ms. Browning filed. I note, as the court is well aware, that this motion was filed after September 1st, 2019. There is no argument that the prior law can apply. And so I think that's important to know. I think the other thing that is important to note to this court regarding the argument made by Mr. Wymore as to whether or not the TCPA should apply, and his argument that, hey, even after 2019 or September 1st of 2019, another Austin Court of Appeals relied or cited to the Hawkshurst case, I think is in all honesty, Judge, disingenuous to this court. And the reason why I tell you that, Your Honor, as you can see in footnote 1 of the cited case, Wendt versus Weinman and Associates, the Austin Court of Appeals in their footnote states the TCPA was amended in the 2019 legislative session, but those amendments do not apply to this lawsuit, which was filed before the amendment's effective date. The Court of Appeals, that this case, as Mr. Wymore would like to convince this court, somehow brings back Hawkshurst after the amendments, or solidifies Hawkshurst as law that, you know, shouldn't have been changed or wasn't changed by the amendments, is just incorrect. The Court of Appeals in Austin specifically recognized that the law had been amended, but that the lawsuit that they were dealing with was prior to the September 1st effective date. I'll also point out that the Hawkshurst, or the Went case that does cite the Hawkshurst case doesn't have anything to do with a motion for sanctions. That case is one in which a former client of attorneys the attorneys had sued a former client for the payment of fees that were not paid, sued them for breach of contract, sued them for quantum merit and some other things. And the defendant, the non-paying former client of the attorneys, filed a motion to dismiss under the TCPA, asserting that it applied. It was not a motion for sanctions. It had nothing to do with the motions for sanctions. Yes, the Court of Appeals in Austin did cite the Hawkshurst case, but not for the proposition that a motion for sanctions under the a TCPA motion can be brought against a motion for sanctions. Instead, it was cited as to what does it mean to petition under the law. And so the case of Went, Your Honor, is just not relevant to this matter. For those reasons, Your Honor, the TCPA motion filed by the movements just isn't applicable. Now, as far as if this court were to determine that indeed the TCPA is in fact applicable to our motion for sanctions, Your Honor, I'll point out that we have the right to establish a prima facie case for each element of our motion, which would be, of course, motion for sanctions under Chapter 10 and Rule 13. The movements, plaintiffs, want to argue that the standard of evidence there is such that it needs to be through summary judgment evidence, and we failed to file any affidavits or anything. Your Honor, I'm going to again go right back to the statute, and it provides under Section 27.006, in determining whether a legal action is subject to or should be dismissed under this chapter, again, the TCPA, the court shall consider the pleadings, evidence a court could consider under Rule 166A, Texas Rules of Civil Procedure, and supporting and opposing affidavits stating the facts on which the liability or defense is based. It doesn't say that that all those things have to be present in order for this court. It just tells you what you can consider. Your Honor, in our motion for sanctions, we've set forth the basis of why we believe that these parties, and now I'm using that term very broadly to include not only the plaintiffs, but their counsel, that they should be sanctioned. And Your Honor, Section 10.001 of the Texas Civil Practices and Remedy Codes provides the following. The signing of a pleading or motion as required by the Texas Rules of Civil Procedure constitutes a certificate by the signatory that to the signatory's best knowledge, information, and belief, formed after reasonable inquiry, the pleading or motion is not being presented for any improper purpose, including to harass or to cause unnecessary delay or needless increase in the cost of litigation. It doesn't require, those things indicate an improper purpose, okay? And then two, each claim, defense, or other legal contention in the pleading or motion is warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. Your Honor, we've pled in our motion for sanctions that they have violated both of those positions. They filed this lawsuit after this court determined they didn't have standing to intervene in the guardianship proceeding, as another effort to attempt to extract remedies out of Miss Browning that they're seeking in Williamson County. Your Honor, it's evident from the pleadings, their petition, that what they're seeking are damages that they're seeking in Williamson County, Texas. That's what they plead. That's what they pled. They're asking this court to give them lost profits, damages to his property, carrying costs for having his loan, and that's what they're seeking in Williamson County, as well as the injunction. The only thing that they didn't plead to this court in their petition is that they want an injunction down in Williamson County for the rifle range. Their argument is based on 1151.105. Your Honor, I think the principal canon of statutory construction, which this court is well aware of, is that you read the plain language of the statute to determine the intent of the legislature in the statute. The statute specifically deals with whether or not a guardian has exercised ordinary diligence in collecting debts or claims owed to the ward, or recovering property of the ward. And if that doesn't happen, and that guardian fails to accomplish that using ordinary diligence and willfully neglects to use ordinary diligence, then a party interested in the estate can bring a cause of action against the guardian and the bond of the guardian, or the sureties on the bond, for the damages related to the failure to collect that claim or recover that property. But those damages go to the estate. This argument that somehow, as plaintiffs have made before the court today, that somehow the law should be interpreted differently, that somehow the law should be extended to basically be a negligence provision or some sort of provision on all acts of the guardian is just frivolous. There is no reason why this court or any court should extend that statute to that provision or to that manner. And so because of the fact that they violated Section 10, as we pled, we believe our motion for sanctions has been proven. We've shown a prima facie case based on the pleadings. As for section or Rule 13, Your Honor, again, Rule 13 provides as follows: the signatures of attorneys or parties constitute a certificate by them that they have read the pleading motion or other paper, that to the best of their knowledge, information, and belief formed after reasonable inquiry, the instrument is not groundless and brought in bad faith, or groundless and brought for the purpose of harassment. Mr. Wymore wants to assert that we have to show bad faith, and the only way we can do that is by Mr. Dickens. Well, that's not correct. The rule provides groundless.
Mr. Odell, let me interrupt you. We are now at just past 11:15. I advise each of you that there is a scheduling conflict at 11:15. You have the right to finish your presentation. Mr. Wymore has the right for rebuttal. I will hear all of that. The scheduling conflict is not really mine. It is the court reporters. And I'm confident that you want a record, each of you, of the completion of this matter and these matters. And so, as I mentioned before, we're taking a recess. Mr. Odell, when we come back, you will be permitted to finish your arguments. And Mr. Wymore, you will be given the opportunity at rebuttal. It's your motion. You have that right to rebut. We will reconvene at 1:45. I'm not sure how is the best way to recess. My thinking is the best way is for us to end this session right now over the Zoom protocol, and my coordinator will very shortly send each of you the information on how to get into a new Zoom hearing. And I say that for the purposes, just for the technological purposes. And we will provide you with that information shortly. She and I will still be here, and so that we can get that information out to you, and should be able to get that information out to you before the noon hour. But at this time, a court reporter must exit. We are in recess. I will end this session, and I will see you again at 1:45. Thank you all.
Thank you.